Hello friends, welcome to my channel. Today we are going to study a very important topic of TPA, that is Transfer of Property Act 1882 of gift. First we are going to deal with the introduction part of gift. According to section 122 of Transfer of Property Act 1882, gift is defined as the transfer of certain existing movable and immovable property made voluntarily and without consideration by one person called the donor and the another person the donee, and accepted by or on the behalf of the donee. Thus, gift is gratuitous gift of ownership in some existing property made voluntarily. Now we come to the essentials of a gift. The first one is the transfer of ownership. The second one is the ownership must be related to a property in existence. The third one is the transfer without consideration. First, transfer of ownership. As the case of sale, there must be a transfer of all the rights in the property by the donor to the donee. It may, however, be noted that it is permissible to make conditional gift. The second one is the ownership must be related to a property in existence. Gift must be made of movable and immovable property capable of being transferred. The third one is the transfer without consideration. If the consideration is nominal amount or the property is grossly undervalued, yet the transfer would not be a gift rather than a sale. The fourth one is must be made voluntarily. The offer to make the gift must be voluntary. A gift, therefore, should be executed with free consent of the donor. This consent should be untainted by force, fraud, or undue influence. The fifth one is the intention or declaration of donor. If the donor wants to give a gift in future to the donee, then he has to make a promise to the donee by making a legal contract or agreement. The next one is the transferability of gift. A gift should be legally valid when the donor of any gift shall deliver or transfer the gift according to the intention to the donee with the promised time. Acceptance of gift. When the donee of any gift will accept the gift made by the donor within the prescribed time, then it should be legally valid. Now we come to the types of gift. The first one is the lifetime gift. When the donor has the intention to deliver any gift to the donee during the lifetime period of the donor, then that shall be considered as lifetime gift. Such gifts are made by the donor to the donee on the basis of some occasions. For example, Mr. V wants to give a mobile phone to his son Q on the occasion on his birthday. Thus, such gift is called a lifetime gift. The second one is the deathbed gift. Such are the future gifts which shall be accepted to deliver to the donee after the death of the donor on the basis of intention made by the donor. These gifts are considered as donation made by the donor to the donee. So, any deathbed gift shall not be effective until the death of the donor. For example, Mr. V wants to donate 1 crore after his death to Q Orphanage Trust as a deathbed gift. The third one is the onerous gift. Any gift which is made with a burden or obligation imposed on the donee by the donor on any immovable property is called onerous gift. This gift is generally the exchange of debt of an object from the donor to the donee. For example, Mr. Q wants to give his one of the building to Gulshan as gift to Mr. E, which has been mortgaged to N Bank for 2 crore. If Mr. E wants to take burden of the mortgage loan to that house by acceptance, then this gift is valid. Now we come to the suspension or revocation of gift. Section 126 of Transfer of Property Act 1882 deals with when gift may be suspended or revoked. A donee or donor can revoke or suspend any future gift which is already delivered or accepted, cannot be revoked or suspended or void. Following are the reasons wherein the gift can be revoked or suspended. If the donee does not want to get any gift from the donor but has been forced to get. If the subject matter of gift is illegal or full of debts, then such a gift shall legally revoked or suspended. If the donor of any gift dies before delivery, then the gift shall be revoked or suspended. If the donor or the donee of any gift is minor or disqualified person, then that gift becomes void. If any gift is presented to the donee with misrepresentation and fraud information made by the donor, then in that case such gift becomes void. Now, the section 126 lays down two models of revocation of gift. That is, the first one is the revocation by mutual agreement, and the second one is by revocation by recession. Now, we first going to read the revocation by mutual agreement. Donor and donee may agree that the gift shall be suspended or revoked upon happening of an event not dependent on the will of the donor. The condition revoking the gift must be expressed in should not be merely in the form of wish or desire. Now there is a case law, that is the Mool Raj versus Ramadevi. The High Court held that since the condition of revocation of gift upon donee failure to render service to the donor was not laid down in the deed, it was unconditional gift and therefore cannot be revoked by the donee. Now we come to the revocation by recession as contract. Gift as a gratuitous transfer of ownership made voluntarily. If it would be proved that the gift was not made voluntarily, that is, the consent of the donor was not free, then the gift must be revoked. Gift is always preceded by an express or implied contract offered by donor and acceptance by donee. Thus, the period of limitation for the revocation of gift on the ground of fraud, coercion, misinterpretation, or undue influence is 3 years from the date on which such facts are known to the donor. Thank you. And if you like the video and if the video helps you, so please don't forget to subscribe my channel. And if you like the video, so please like the video and share with your friends. Thank you.